Welcome to today's podcast. My name is Burke and I will be your host. Today's podcast guest is Kelly VanBuskirk. Kelly is with the Lawson Creamer Law Firm and specializes in labor and employment law, civil litigation, administrative law, and business immigration. Kelly is here today to talk to us about a concept called respectful workplaces legislation, the requirements, and a couple of other cases that also deal with the issue of respectful workplaces. Welcome, Kelly.
Hey, hi, Pearlie. How are you?
Very good. For folks who may have missed your previous podcast where we had you tell us a little bit about your background, I mentioned a few of the employment areas that you work in. I wanted to talk a little bit about some of the areas that you do work in on a day-to-day basis.
Sure. Yeah, no, I for 30 years have practiced labor, employment, and human rights law primarily. And in that practice, I've represented individuals and organizations from almost every perspective, employers, employees, unions, tribunals. I've been fortunate to serve as an arbitrator in more than 35 cases involving mostly occupational health and safety and collective agreement grievances. And that work has, taken me into sort of a side field of researching workplace conflict and providing training services strangely all over Pearlie, from California through to New York and the United Kingdom. In fact, just recently was asked to go to the United Kingdom in June of this year to talk about workplace harassment. So it's been a strange but entertaining ride.
Now, for today's podcast, just to set the tone, in New Brunswick, under OHS legislation as of a few years ago, there was a requirement that all workplaces develop a code of practice for workplace harassment and violence. Harassment, and to me, it's very important to look at the definitions provided in the legislation. So I'm going to quickly read the two definitions, and then I'll have Kelly get into some of the practicalities. Harassment in a place of employment, the definition, means any objectionable or offensive behavior that is known or ought reasonably to be known to be unwelcome, including bullying or any other conduct, comment, or display made on either a one-time or repeated basis that threatens the health or safety of an employee and includes sexual harassment, but does not include reasonable conduct of an employer in respect of the management and direction of the employees at the place of employment. So that's the definition straight from the legislation. The definition for violence is this: violence in a place of employment means the attempted or actual use of physical force against an employee, or any threatening statement or behavior that gives an employee, and that to me is a critical part of this definition, that gives an employee reasonable cause to believe that physical force will be used against the employee and includes sexual violence, intimate partner violence, and domestic violence. Now, many workplaces have developed a code of practice on these two topics, and often I've seen in practice that it's referred to as a respectful workplace code of practice. So what they've done is they've really just taken those two areas, two topics, and say, look, let's put it under one umbrella and we'll call it a respectful workplace, i.e. is expected. So my first question to you, Kelly, is what's your take as someone who's practiced in this area a lot, what really is meant by the term respectful workplace?
I think all of this came out of a number of cases, law cases, that really started to emerge in the 2000s, Pearlie. There were some hints of them even in the 1990s, but by the 2000s, there were questions about how people were treating each other in workplaces and whether or not the treatment constituted harassment. I think that, for example, in Ontario, one of the landmark cases is Boucher against Walmart. And that's a case where an employee was subjected to treatment that she characterized as harassment on the part of her supervisor. And I think most of us could come to the conclusion easily that in that case, the treatment was harassment because the supervisor was making fun of this employee, was demeaning her, belittling her, very vocally and publicly telling her and others that she was, not very bright and incompetent. Since then, there have been, a whole string of cases like that one. And what the legislators have concluded is that this behavior, this harassment, is causing disability, psychological disability for so many employees. And then they're ending up on sick leave. It really has a devastating impact on workforces generally. And so I think like the Bill C-45 discussion that we had in the past, Pearlie, I think, governments across the country said, look, we've got to do something about this workplace harassment because it's, it's really affecting too many people.
So someone comes to you and says, look, you've been practicing in this area for a number of years. What should the steps be from the point of view as we put our policy together and our procedures? What should the steps be from a point of view of if I have a complaint, what should happen to it next and so on all the way up to sort of the chain of command, the ladder?
Right. For a lot of my employer clients, one of the questions that frequently arises is, look, I just had an employee come to me and verbally express that they had been harassed. Mm-hmm. I take it that's not a real complaint. And my answer is, under the legislation, I would say that is a real complaint. Whether it's put in writing or it's verbal doesn't matter. If you as an employer become aware of an allegation of harassment, then you have to treat it as harassment. And that leads to your next question, Pearlie, which is like, what should the employer do? What are the steps? I think first, there should be an effort made to document the complaint. If it's a complaint that the employee has put in writing, then that documentation is a good start. If the employee has only expressed it verbally, then the employer should, commit to putting the complaint in writing. So there's a document. Then, that complaint should be investigated. And I'm speaking in, basic terms, if I could, because there are nuances with all of the different harassment legislation across the country. Mm-hmm. But essentially, there has to be an investigation of a harassment complaint. The investigation should be conducted by somebody who is impartial. And to give an example on this, Pearlie, like let's say you're my boss, and let's say that Bill Walker of Safety Services is your boss in the example. If I make a complaint about Bill Walker harassing me, would you be the appropriate person to investigate the complaint? The answer could be no, because you're tied to Bill. You have responsibilities to Bill. And so one of the questions that every employer should ask is, the investigator that we are appointing to examine this harassment complaint, is that person sufficiently impartial? And so that's, something that should be considered. Once there's an impartial investigator appointed, and it can be somebody within the company, there are, in fact, some legal benefits to having a person inside your company do the investigation. But once they've done the investigation, they should write a report. The report should, outline what the complaint was, who was interviewed as a witness, what evidence was collected, and on a balance of probability standard, what was the outcome? In other words, is the complaint founded or is it unfounded? Did harassment occur or did it not occur? And then once that decision's made, all that's left is to decide what should be the penalty.
Now, when you talk about in-house versus external, I've made a complaint against my supervisor. We all know that organizations sometimes will tend to want to bury issues or concerns or complaints. Is it better to have an in-house? I know you say there are advantages to have an in-house, and I can understand that. Who would you really find in-house that wouldn't have some sort of impartiality, or would be impartial, I should say? HR, for example, human resources?
Possibly.
Is there anyone specifically, or should you go outside?
This is a question that many organizations wrestle with, and many employees, especially people who make complaints, they really wrestle with this. And I think I'm picking up on your point, Pearlie, which is a great one. Can an employee who makes a harassment complaint have confidence that an internal investigator, somebody who works for the company, is going to, do a fair, thorough investigation? I will say this. There is an argument that the legislation, no matter where you are in Canada, has a gap, because what it does do is it's the government saying to employers, hey, look, we have this harassment problem. If an employee of yours makes a harassment complaint, you, the employer, have to deal with it. And that means you either have to have someone internal to your company investigate the complaint, or you have to pay somebody external to your company to do the investigation. One of the problems that so many complainants have is, does it really matter? Like if somebody from the HR department does the investigation, I, as the complainant, may still question whether it's valid. On the other hand, if the company hires an investigator who is external to the company, and that person is being paid sometimes large amounts of money, like $20,000, $30,000, $40,000 to do an investigation, are they really independent?
So how do you find someone that's independent? That's a loaded question.
The legislation doesn't really require it right now, which is a potential problem. When we talk, when you and I talked a time ago, Pearlie, about the Section 217.1 of the Criminal Code, the supervisor criminal liability case here in New Brunswick, in that instance, there is a Crown prosecutor assigned as an independent body to put together a case and advance it to a judge who is another independent body. And, there are still arguments about, the fairness of that process, but it's pretty difficult to argue about the fairness of that process compared to these harassment complaints. And I think that's your point. Should a government appointed investigator be the investigator of harassment complaints?
So if you do have to go outside or if you do end up going outside, are there any organizations that like human rights commissions or human rights ombudsman, and there's all these different groups and individuals we hear about, are there any that you consider ones that are providing that kind of service?
Well, if the complaint that arises in a workplace has to do with one of the 16 prohibited grounds of discrimination under our New Brunswick Human Rights Act, for example, then a complainant can go directly to the Human Rights Commission and can obtain the potential for a commission-conducted investigation into that discrimination. But when it comes to harassment allegations, it's less certain as to who would do the investigation. The government of New Brunswick has an approved list of investigators, that might be some place to start, but you would still end up in this conundrum about the fact that the investigator is being paid by the company.
So I filed a complaint. The organization has dealt with it. I don't think it's adequate, whether it was done internally or externally. What's my next step as an employee? Hire a lawyer?
Honestly, that probably is the next step. And I'll tell you what, if you're unionized, then you would go to your union. But the problem is that it's such a nebulous area that, in a typical case, let's say you go to court for a speeding ticket and you're found guilty of speeding and you get a fine. Your next step is to appeal the decision of the judge to a court. In this harassment context, the next step is really fuzzy. Like if you're a provincially regulated government employee, you can perhaps seek judicial review of the decision made by the investigator. But if you're not a government employee, the question is a lot more difficult to answer. You could sue your employer in certain ways. It's not an easy lawsuit to make out. What does happen though, Pearlie, that people may find at least somewhat comforting is that the legislation talks about not being discriminated against because of an effort to enforce safety regulations. And that shows up in the Occupational Health and Safety Act. It also shows up in the Employment Standards Act. And so let's say you make a complaint. The employer says that it's going to investigate the complaint. The employer does somewhat of an investigation, but not one that you're satisfied with. And then let's say a month later you get fired or laid off. Well, then an employee should consider making a complaint under the Occupational Health and Safety Act for discrimination or under the Employment Standards Act for discriminatory treatment under Section 28.
So you would send me some information on a couple of cases where that actually happened. Do you want to take a few minutes and talk about each of those cases?
Sure.
Just
to
give folks this is what happens in real life.
Yeah. No, I'd be glad to, because I think this is an issue that is affecting so many employees across the country. On that point, by the way, Statistics Canada tells us that somewhere in the range of 60% of Canadian workers have been subjected to harassment in their workplaces. So, with that number of people experiencing harassment, there are a lot of these complaints being made. In the two cases that I passed on to you, the outcomes are interesting because what happened in each of them was that the employees made complaints of harassment. The employer purported to do some kind of investigation. The investigations weren't satisfactory to the employees. And then shortly thereafter, in each case, the employees were dismissed from their jobs. So in the first one, it was the case of Burke against the province of New Brunswick. The spelling is Burke. And this was a person employed as a contract coroner for the province. This person made a sexual harassment complaint to their supervisor. Based on the evidence, it would appear that the supervisor who got the complaint really didn't do too much with it. And then, based on the evidence, it would appear that the employer shortly after the complaint was made, decided to terminate the employee's position. And so the employee said, look, that doesn't seem fair. I just made a harassment complaint and now I'm being laid off. There must be some connection between the two. And there was first a decision made by an arbitrator, and then that decision, which was in favor of the employee, was appealed by the employer, and the Court of King's Bench upheld the arbitrator's decision and ruled against the employer. What the employer said was, look, we didn't fire this person because they made a sexual harassment complaint. We just fired them because of some other reason. And I think what's really important is that the court said, look, no smart employer is ever going to admit that they just fired the employee because the employee made a harassment complaint. The employer's not going to admit that. So we as arbitrators and judges have to recognize that there is what the courts call a subtle scent of discrimination, like a sort of a faint smell of discrimination. And so in that case, the court said, this doesn't add up to us. We think that this woman was fired because of her complaint, and she was ordered to be reinstated to her position.
Now, in a case like that, to be reinstated, now that's putting her back. People would quickly say, hey, that's putting her back in a very precarious position.
Mm.
What do you tend to see there? Is it more common for people to say, look, no, I don't want my job back because obviously at this point, you're putting me back in a very, very precarious position. I'd prefer a payout of some sort.
Yes, that's a fair point. I think for many people, they don't want to expose themselves to, more emotional injury, to the stress and strain of being right back in the environment where, they were unjustly treated. But on the other hand, for some employees, reinstatement is the best remedy. And the reason it is because, well, take a government employee, for example. All the losses that occur, including pension losses and
there's a
income
lot.
It's devastating to people.
It's substantial. And then there's a future getting a job, another job. And people ask about, well, what was your last job? And, how do you explain it? And
that's that came up in the second case that I sent you, this case of Campbell against Opportunities New Brunswick. And, that's a really good point, that people who make these harassment complaints are supposed to be protected from discrimination later. But we can all imagine how that doesn't really work. Because to your point, Pearlie, if somebody makes a complaint and they end up being terminated later, one of the very common reactions that future prospective employers will have is, hey, you must be a troublemaker, right?
Mm-hmm.
Like, look, I don't think I want to get tied up with you because, you got fired and there was this complaint, and I don't, it sounds to me like you're the problem. And that's unfortunate, because these policies that you referenced earlier that are required under the Occupational Health and Safety Regulation actually impose an obligation on the employees to report potential harassment. So,
now, the second case you referred to just a moment ago with the Opportunities in New Brunswick, can you tell us a little more about what happened in that case?
Sure. Yeah, it was somewhat similar to the Burke case in that this fellow, Campbell, was working along for the organization. The organization had a policy which, recommended that complaints be made in the face of harassment. The decision of the labor board in that case outlines some of the behavior that Campbell identified as harassment, including having a supervisor lean over a desk, point their finger in his face and say, I'm not effing asking you to do this. I'm effing telling you to do this. Excuse my language, Pearlie. But, and there were more examples than that. So the guy makes a complaint. And in his complaint, which the labor board has in evidence, the complainant outlines 17 different witnesses So he says to the employer, look, this happened, and here are 17 people that you should talk to about that. The employer hires an external investigator. The external investigator talks to one person, the complainant, and then says, oh, there's not enough evidence to even go further with the investigation. Now, what the labor board points out is that that's problematic, because if the only person you spoke to is the one guy who says that these things happened, and if these things include stuff like, I'm not effing telling you I'm not effing asking you, I'm effing telling you to do it, that kind of stuff, then, it's pretty hard to say there's no evidence of harassment. And so in that case, the external investigator made a conclusion that there was no harassment, and almost exactly a month later, Campbell got fired. In between, by the way, he got a favorable performance rating, like a performance review that said, words to the effect of, everything's fine. And later, the employer gave Campbell a letter of reference that said he was great, really. But then he was dismissed. And so in a way that was similar to the Burke case, the labor board in the Campbell case concluded that his complaint did have something to do with getting fired. And then that leads us to this question of what's an appropriate remedy at that stage.
So what did they decide in his case?
It's still up in the air. The labor board directed the parties, Campbell and OMB, to talk about, what should be an appropriate resolution. And there hasn't been one yet.
So based on your vast experience, is the system working? Or do we need it tightened in certain ways? If someone were to hire you and say, look, we're going to give you a month. We want you to come back with a series of recommendations. You've worked in the field. You see what's working. You see what's not working. Make some recommendations that would help make our system work more efficiently and provide some better balance. What would you suggest?
One possible improvement to this current system would be the establishment of a board of independent, neutral investigators. And I recognize that comes at some cost. And so unfortunately, the cost of that neutral board would have to be borne probably by employers. But that's one improvement that should be made. In my mind, I think a second one is that there should be some opportunity to appeal an investigator's decision. That's really not viable for most employees right now, and so there should be some way to appeal those investigative decisions. That's a second improvement that I would make. I think the third one is that while there is a requirement under the legislation for employers to implement training for all of their employees, there really isn't a stipulation as to the quality of the training. And I think, the literature, the studies tell us that some of that training isn't very effective at all, and some of it's quite effective. I think that there should be a requirement for everyone to be directed toward that effective training and not the ineffective training.
So you've been invited, as you mentioned, to a number of different locations. Are they to deal with cases, or is it more of an educational process that people are asking you to come and help educate them on what should be done and what shouldn't be done and so on?
Yeah, both, but more so the latter, training people in terms of, how to create more, safety sensitive, and respectful workplaces. And, none of us are experts at this. I mean, we can all recognize really easily, Pearlie, that, we all offend other people. I do, and I'm sure all of your listeners do. What we can, though, try is to reduce the number of times that we offend other people. And so the training that I've been working with a lot of different organizations on has to do exactly with that. How do we take the person who's sitting in an office in Sudbury, Ontario, or in Huddersfield, England, and compel them to think more carefully about their own behavior and their own attitudes so that they will treat other people more respectfully? That's a fascinating exercise.
Now, a hot topic these days in health and safety is psychological safety in the workplace.
Yep.
See in article after article, I know, on LinkedIn and in various resources talking about psychological safety in the workplace. What would be your take if someone comes up to you and says, look, this is really very much tied into harassment and violence and so on, is how do you make, if you were to give someone or an organization tips on how do I make my organization psychologically safe for my employees, how would you answer it?
First, I would go to the Canadian Standards Association. There's a psychological safety standard. It's a 13-step standard that is pretty easy for employers to use. That's a good starting point. Second, every employer can, do what I would consider to be a common sense analysis of your workplace. You have to do this in a structured way, though, and what it involves is really looking carefully at where friction points exist. Pearlie, every employer that you ever talk to could, I'm sure, identify an employee or a former employee who tends to mistreat their coworkers. They're grumpy, they're dissatisfied with their life, they're angry, they have an anger management problem, they're, whatever the case is. And those people are potential psychological safety risks. So the employer can start to identify where these friction points exist. Another one is, if you work in a high stress environment, we can all think of high stress environments like on the floor of the stock exchange in Wall Street, and where everyone's yelling and screaming and so on. Those are places where there's going to be a psychological safety risk, or a more prevalent one. So employers can identify those risks and then start to apply those 13 factors in the standard. A lot of that will require firm, consistent leadership. And if you don't have firm, consistent leadership in your company, then it's never going to pan out for you, because there's no way to establish the standard that you're trying to achieve.
A number of years ago, I did some courses on workplace harassment. And one of the comments that came up from a number of people who especially worked in the area of the public, made comments to me. They said, look, we've had issues in the past, and you bring it to your supervisor, and the response of so many supervisors is, well, hey, that's part of the job. Yeah, customers getting mad at you and complaining to you, working in a healthcare environment, patients hit you, strike you, in an education system, the same thing. Look, you talk all you want about harassment and violence, but look, that's part of the job. Get over it. How would you respond to someone making that kind of comment?
Well, I think in New Brunswick, we've seen some examples of why that can't be the response. In Moncton, the case of Natasha Poirier, who is a nurse manager, and she was cornered by the husband of a patient in the hospital, and in a secluded corner, and was dragged by the hair and beaten up for 11 minutes before anyone came to her rescue. There's a case in a retail setting in New Brunswick where a customer jumped over the cashier's counter and started pummeling the employee. There was a case of a hotel worker who was working the night shift and was held up at gunpoint. These are all things that can happen if we don't take seriously the safety risks that surround them, right? So I agree with you, or I agree with what I think you're saying, that we can't accept the idea that violence or harassment are part of the job.
Yeah, that's, I tend to refer to it as sort of old school thinking. It's certainly not the way we look at it now, and that's not what's expected. That's not the norm anymore. One last question. Best practice. You've been to a number of different jurisdictions. Anyone out there that has legislation or systems in place that you've seen and say, hey, that's good?
Well, I'm always interested in Finland, which has had some success in reducing the incidence of harassment in their workplaces. I think Canada has put in place some measures that could work if adjusted in the ways that you and I talked about a few minutes ago. I think that one of the areas that I'm researching now and that I'm seeing as a possible best practice emerging is revisiting the concept of humility in workplaces. And what I mean by that is really requiring employees to think about their own behavior in a humble way, with acknowledgement that they are going to offend people just like people are going to offend them. It looks like, based on the early research, that kind of rewiring of our brains can help improve behavior at the outset so that we don't experience harassment, let alone have to deal with it through policies.
Well, look, thank you very much for joining us today, Kelly. Very much appreciate you taking the time to talk about this topic. There's so many different topics in health and safety that are covered in different aspects of legislation. Hopefully we can have you back at some other point as other topics come up. Thank you very much. We appreciate you taking the time. We know you're really busy. As is always the case, we appreciate your feedback on today's podcast, as well as any ideas you have for future podcast guests or topics. You can always reach us at podcast@ssnb.ca. Stay safe. See you next week.